So firstly then, we'll kick off with the removal of section 21 notices. So this is probably one that you've most heard about with regards to this bill. So currently under the Housing Act 1998, landlords can evict tenants without giving them any specific reason, given that they provide them with the correct notice, which is currently 2 months. So under the new bill, this is going to be scrapped altogether. So that means that landlords won't be able to end a tenancy without giving them a valid reason to regain that possession. And instead there will be strengthened grounds under possession under section 8, which requires this legitimate reason. And that is rent arrears, antisocial behaviour, or if you're a landlord wanting to sell or move back into that property. So that moves on to no more fixed terms. So this change alongside section 21 does mark quite a major shift in how tenancies are structured in England. So most tenants in England start their journey off on an AST, and that starts with either 6 or 12 months at the moment, after which when the tenancy either ends or renews, a further fixed term begins, or that rolls on to periodic. So fixed term tenancies, so they're going to be abolished altogether in favour of the periodic tenancies, and this does mean that all new tenancies will be open-ended from day one with no pre-agreed end date. So tenants will be able to give 2 months notice any time to leave, whilst landlords, as I touched upon before, will have to give these strengthened grounds, which in certain circumstances might be 4 months notice, less dependent on obviously what the reasoning behind that. And there'll be no transitional period for existing tenancies either. So from day of implementation, we'll transition to periodic. So this then brings on to notice periods. So, for example, so if a tenant wishes to vacate, they can bring their tenancy to an end at any time, provided they give the 2 months notice. And this changes from the current 1 month's notice that they can give you at the moment. And then going into further detail on the other 2 points. So if the landlord, you wish to sell the property, it's 4 months notice required, or if you wish to move back into it as well. So the change in notice periods. So again, touching upon those last 2 points in further detail. So if a landlord intends to sell the property or moves back into it, they've got to give this 4 months notice. And this will be done using a ground 1A, intention to sell. And it's really important and crucial that this is understood, because it comes with quite strict guidelines to ensure that it's not misused. So the notice must not expire within 12 months from the start of the tenancy. So in theory, at month 8 of the tenancy, the 4 months notice can be provided to end it at month 12. So once the tenant vacates, there will be a 12-month relevant period. So the relevant period is a 12-month period which the landlord cannot re-let the property. If the landlord does, they will face financial penalties, and we're talking, a couple of £1,000 if that property is re-let within that time. So, it's to be taken quite seriously. So I guess really, if you are a landlord and thinking of selling, when this change happens, you've really got to be committed to that process, and just bear in mind, if the property doesn't sell as planned, then you'll have to pay your mortgage payments, your insurance, council tax, standing charges on utilities, etc., etc. So again, must be really carefully planned using that ground.
Sorry, who said you monitor that?
Sorry?
Let's say you don't want to rent it anymore and you want to sell it, and then it didn't work out and then you rent it, so who monitored that bit?
Well, essentially, obviously, the government as such. Yeah, essentially. So, yeah, it's quite a long time.
Sorry, I'm using country.
No, yeah, no problem. Has anyone else got any questions at all? Yes, Sarah?
So if you've got a corporate landlord, they can't move into the property, can they? So they can't use that ground.
I wouldn't say so, no.
So pretty safe if you're... They could say they were selling. Yeah.
Can you not use it for a family member?
This is the thing, I mean, it's how tight are these certain aspects of it going to be? It's very, obviously there's still, which I'll talk about, but it's amendments to go yet, but it's these like neat little questions that we really need to know the answers to in order to effectively know what we're doing. But yeah, it's a good question.
When it comes to a thing, which day, what's the date?
Oh, it's later down the line. You're going to talk about that?
Yeah, I'll talk, yeah. Just hold on. I'll come to that. You're very keen. Okay, right, we'll move on to rent payments then. So rents must be charged monthly or in 28 days where rent is paid weekly, but nothing longer than this. And shorter periods are allowed, but nothing longer. So rent payment in advance will be unacceptable. So at the moment, you might ask your tenant to pay 6 months rent in advance. They may have credit issues. They may struggle with getting a guarantor. So, you know, we do ask for tenants for rent in advance quite regularly again, so that's going to be scrapped as well. And a tenant under assured tenancy is also entitled to be repaid any part of that rent that relates to days falling after the end tenancy as well. And then finally, tenancy agreements must be executed before the first month's rent is demanded. So at the moment with tenancy agreements, so obviously you'll send the tenancy agreement out to the tenant, they sign it, they pay you the monies, and then you sign it off once they've collected the keys. So moving forward, you've got to sign the entire agreement and start the agreement before asking for that money. So, rent arrears. Hope I've not scared you all off yet. There's positivity at the end. So the number of months that the tenant is in rent arrears before issuing the notice. So at the moment that is 2 months notice. That's being extended to 3 months notice, again under possession of ground 8. And then the notice period, so section 8 that you would serve on your tenant, so that's currently at 2 weeks, and that's also going to be extended to 1 month. So the time to apply for possession via the court, so by the time they've got into arrears and then you've served the section 8, it's about 2.5 months, and that's going to jump to 4 and a bit months. So it's, yeah, as I say, quite a big jump. And it's also important to note that any arrears incurred from the delay in universal credit payment cannot be accepted towards the ground for the notice either. So rent increases. So rent increases, so these can only be implemented using the statutory section 13 notice. And this notice is being extended from the current 1 month's notice up to 2 months. And you will not be able to impose any excessive increases or unrealistic increases. They can only be at either the market level or below. There's also, so with your contract, so you also cannot implement anything in the contracts moving forward. So you can't put it's going to be, you know, in line with CPI, or it's going to be increased X amount of time. And if the tenant believes that the increase is unfair, they can also take this to the first tier tribunal as well, so they can challenge this. If it is taken to first tier tribunal, any increase will be placed on hold and won't take effect until the tribunal determines the new rent payable, so there's no backdating. And however long it takes to get to tribunal, the rent can't be increased during this time. So when it gets to tribunal, they can set it at a lower rent if they propose, but it's no way that it can go over that section 13 that you've tried to implement. So again, it's the same or lower. Any increase needs to be completely justifiable and evidence provided to back that as well. If you are using an agent, so we have all these portals, Rightmove Plus, that we can provide all that evidence to the tribunal service should we need to do that. And also goes without saying, if you've not increased the rent on your properties for a while, you need to look at doing that now. Now's the time to do that.
So, the first tier tribunal, what's the timeline? So I'm only thinking that these people get completely inundated with requests. You can't increase your rent.
No, and it's going to get worse.
So it just sits there for 18 months, 24 months before you get to first tier tribunal. So, first tier tribunal says you need to pay a little bit extra, backdate it, tenant says thanks ever so much, I'm off.
Yeah. So
is that the reality of?
So at the moment, so the ones that we've had that have come through the tribunal, in present circumstances, average out between sort of like 6 to 8 weeks. So it's not unreasonable, but at the moment you can still, so if the tenant takes it to tribunal, they're still expected to pay that increase until then the tribunal serves determine it. So they're changing that around, but obviously I think more of this is going to happen as, you know, tenants get word of all this happening, and obviously it's going to be longer in circumstances. So yeah. Yes?
On When you say you can't backdate it, does that mean that, let's say hypothetically you had a tenant and you were charging them £1,000 a month and you tried to increase it to 1,100 and they said, I disagree, I'm going to take it to tribunal. Let's say it takes 3 months to get to tribunal and they're still paying £1,000 a month.
Yeah.
And does that mean that tenants are kind of incentivised to dispute it regardless because
Possibly.
they're saving £300?
Ultimately.
If they do think it's fair.
Yeah, because if the tribunal go, actually, yeah, 1,200 quid, 1,300 quid.
You still save yourself £300 quid.
Yeah.
Because that 3 months. That's so bad.
Yeah, the reality is it ain't going to be 3 months. The reality is it's probably going to be 2 years, isn't it?
Essentially.
So yeah, so tenants are kind of
Contingency budget.
incentivised. If tenants are incentivised, presumably they're going to get even more requests and become even more inundated. So then it could actually be, you could secure your rent for like 5 years while you're waiting.
Essentially, yeah.
Wow.
Yeah.
You thought that through.
No. But yeah. Any other questions? No, okay. So, where am I? So, housing standards then. So, also part of this bill is on a mission to raise the housing standards within the private rented sector. So this bill focuses on improving quality, accountability and transparency on what is acceptable and what isn't. So the bill will introduce a new private rented sector database. So basically that is a central register of landlords and properties within the sector, and landlords will be legally required to register themselves and their properties on this platform. So tenants can ultimately check that. Councils can check that for data as well to make sure that you're compliant. And if they need to obviously support, they'll have the data to support enforcement as well if necessary. The database will also include links to the redress scheme, which I'll come on to. So landlords need to register or keep information up to date, otherwise they will face potential fines and penalties if they don't. So the redress scheme, so that's basically a platform which will offer tenants a clear and formal route to resolve complaints. So as letting agents, we are already part of a redress scheme because we have to be. And as I say, that will also be applied to landlords directly as well. Another significant change, the first time that the decent home standards, which is only applied to social housing, will also be extended to the private rented sector as well. And the decent home standards are there to set a clear benchmark that properties must be free from certain health and safety standards in a reasonable state of repair. So that is an extension to the Arabs law into the private rented sector. So that law was named after, unfortunately, that 2-year-old little boy that died after exposure to mould in his home. So this law, it does require timely and prompt responses to resolve issues once they are reported, and any serious hazards around damp and mould, there's a really tight time frame on getting those resolved. Landlords who fail to act in the timeframes could potentially face fines up to £7,000 for initial breach and up to £40,000 for repeated breaches or even prosecution. So it is a heavily weighted new rule, but ultimately, it's there to do what it's set out to do and raise the standard of homes in the private rented sector and hold landlords to account who consistently fail to maintain a decent living conditions. So, rent repayment orders. So this allows your tenant to claim back rent during a period of time when the landlord has committed specific housing offence. So under the new current rules, tenants can apply for up to 12 months rent to be paid in such cases, but the bill is going to double this to 24 months of rent paid. And in addition to that, the time frame in order to report these offences is also increasing from 12 months to 24 months as well, giving tenants and councils to take more action. And again, the goal here is to deter landlords from cutting any corners with regulations or putting tenants at risk. And it does serve a reminder that compliance is essential, not optional. So rent bidding, so more common in sales, you bid on houses rather than in lettings. But if you have multiple applications on a property, which does tend to happen these days, and tenants want to bid more, you cannot accept this moving forward. So any offers and pricing should be set as advertised. And again, there are penalties of up to £7,000 if the local housing allowance believes that that has happened. So it is really imperative to make sure that you've you've been advised correctly by your agent, you've got that rent where it should be from the get-go. Pets. So with the new legislation, and once tenancy has been granted, landlords can no longer unreasonably withhold pet requests. However, in sort of superior lease cases, like if you've got sort of an apartment in a building, then that will oversee that. But landlords can request the tenant to pay for pet insurance. There has been a slight sort of amendment that this week, so there's still umming and ahhing as to whether the landlord can actually request the pet insurance at the moment, so they're still talking about that, but hopefully that does come into place. Any other questions at this point? Yes?
Sorry, me again. When you say like they can request pet insurance, pet insurance I thought was for the health of the pet, not for like the upkeep of the property.
So
Does pet insurance cover like dog
damages, so it'd be a pet insurance for like damages to fixtures and fittings ultimately.
So not actually your normal pet insurance that you get from pets.
No, it'll be separate. Yeah, so for example, we tend to ask tenants for tenant liability insurance at the moment before they move into a property. So that would cover you if you like your fixtures and fittings. So if they were to like similar things, so if you put a pan on the worktop and it burns the worktop, for example, we went and did an inspection and said, right, we need to claim on your insurance, we need to get this sorted. So similar sort of principle with where that's concerned.
You know the redress scheme?
Yes.
Does it specifically have to be PRS, or can it be like the property ombudsman, or does it have to be?
I don't think it has to just be PRS. I think it can be alongside any of those sort of schemes, yeah.
And with that, do you need to have like an internal complaints procedure before it goes to the PRS or anything like that?
They've not specified yet. They've just said that basically landlords will need to be part of a redress scheme on some sort of platform. So yeah, there'll be more information on that as and when it comes, but yeah. Okay. So let's have a quick look at the timeline of the bill so far and what's going to happen next. So back in January, the bill was moving at quite considerable pace compared to when it was introduced by the Conservative government last year. So now we're about sort of over halfway with the bill in the House of Lords, and we had thought that this sort of stage would be finished by the end of June, but given the complexities of it, it wasn't. So we've now seen the committee stage, so just to break this down, so there were 11 sessions over 7 days of debate, and there were a total of 333 tabled amendments of the bill, which only 42 were agreed, and 230 of them were voted and decided would not move forward. So now we've got these 42 amendments, which seem to be sort of ever long, but there's sort of more like technical amendments that they're looking at the moment and don't really change the overall of what the bill is going to entail. So where are we going to go next? So next within the Lords process is to go to the report stage, which began this week on the 1st of July with the next provisional date set for the 7th and 15th. And once that report stage is completed, we'll then get the final stage in the House of Lords, which is known as the third reading, which can sort of seem as quite a daunting stage, but it's relatively quick. And then this will then bring the bill of the House of Lords process, which will go back into the House of Commons, also known as ping pong. Interesting term, isn't it? So this is where the bill will go back to the House of Commons, and they'll basically look at these amendments, and a decision will be made as to what amendments will be accepted and which ones will go back to the House of Lords for further debate. This can happen either over a long period of time, or it can happen relatively quickly. And given the amendments which are currently in the amended bill, there's nothing sort of overly controversial. So if the process happens quite quickly, it will go to royal assent, which is where the bill becomes law. So at this point, Parliament and the Housing Minister have promised the industry and landlords there will be this implementation period, which we're sort of expecting to be about 2 months from the point that it gets royal assent. But we are told that they are keen for it to be implemented at least by the end of this year. So it will come into place in some form, and then a stage process probably a bit later on. So how you can stay compliant now, what can you do now? So the best thing you can do is sort of get all your paperwork in order, checking your properties, that you've got your gas safety checks in place, EICRs. These were brought into effect 5 years ago now, so a lot of them will be obviously coming up for renewal this year. Your prescribed information, making sure that all your deposits are registered correctly? And does your property meet these new housing standards as well? Are there any repairs, works that you need to look at doing now moving forward? And also think tenant. So what are your plans with the property and your tenant? Are you considering moving back in it? Have you got the right tenants in place? Is the rent at the correct level? So these are really sort of key questions to ask now. And also rent guarantee insurance. Obviously all these periods are going to be extended. Rent guarantee insurance is really something that I would look into. And also using the right agent. So making sure you've got as much support as possible and you're being given the right advice. Are you using an agent that's part of this registered ombudsman scheme? Do they have client money protection? And do they have the right accreditations in place? So for example, we're a member of Property Mark and we have to adhere to certain standards and practices within the industry already. Any other questions? No? Okay. So, I do appreciate there's a lot of change and a lot to digest in all of that. But there's always going to be a demand with the private rented sector. There's always going to be a need for housing. It's a lot of change, but it's just another hurdle for us to get over. And once it's settled down, it will become the new norm. If you have got property investments within Lincoln or you're looking to invest in the market, we do offer competitive packages, residential management. If you're looking at buying or now selling, then residential sales. We also specialise in student accommodation, HMOs, mortgage advice bureau, auctions, and we can also offer you investments and refurbishment advice as well. And of course, if you have any one-to-one questions, I've got Abby and Kieran with me as well, so if you want any advice, then please give us a shout. Any more questions?